Hello and welcome to Moose Court. Today it's a competency hearing with Judge Middleton, and it's a good one.
All right, good afternoon, Mr. Juday. This is Judge Middleton. I'm here at the courthouse in Centerville. Also present is your lawyer, Rhonda Ives, and prosecuting attorney, Angela Camfield. Your brother, Mike Juday, has also joined us here for this hearing. To recap, Mr. Juday was charged in May of 2024 with home invasion, third degree, and malicious destruction of property over 200 but less than 1,000. Malicious destruction of property over $200 is a misdemeanor punishable by up to a year in jail and a fine of up to $1,000. The home invasion charge is a felony, and it is punishable by up to 5 years imprisonment. Defendant was arraigned on those charges, and he's been in custody now for more than a year between jail and the Forensic Center. As of May 24th, he was in jail for 365 days. He had been in jail for 456 days at the Forensic Center. Our last hearing was in May, and we had received a letter from the Center for Forensic Psychiatry that they believe that you're still incompetent, but that you are restorable to competence. Most of the issue here, as I've seen it, Mr. Juday, is you just won't talk to anybody. You didn't really want to talk to me. You didn't want to talk to your lawyer. You didn't want to talk to the people at the Forensic Center. You just wish we would all go away, but we're all stuck here. I have received a most recent report, date stamped August 12th, from the Center for Forensic Psychiatry. It's by Graham Parker, limited clinical social worker, certified forensic examiner. Ms. Camfield, on behalf of the prosecution, may we consider that report for this hearing?
Yes, I would allow that, Your Honor.
Ms. Ives, you concur?
I concur, Your Honor.
I'll get right to the bottom line, and then I'll quote further from the report. The conclusion of Dr. Parker, or clinical social worker Parker, he's not a doctor. It is my opinion that Mr. Juday remains incompetent to stand trial at this time. It is believed with continued treatment, he will be likely to meet the statutory criteria for competency to stand trial prior to the expiration of the treatment order. And I believe the treatment order is good. I was trying to look at it. I think it's 15 months. So at some point, if we don't get where we're going, we're going to have to pursue a different cause of action. Back in July of 25, a previous doctor, Dr. Journey, Jouney, Jouney, stated, since his admission, Mr. Juday has been unwilling to speak with members of his treatment team. When I asked him to meet with me, he entered the interview room, refused to sit, and asked, and then left without answering any questions. His social worker, the chief clinician, reported similar encounters. They reported Mr. Juday's conduct as generally good. He's made friends, he's adhered to unit rules, and been responsive to staff requests. He's not displayed any irritability, aggressiveness, or atypical behaviors. He's not been prescribed any medicine other than olanzapine, which has not been taken. And then here's their opinion. The concerns relating to Mr. Juday's previous competency evaluations continue to remain present. Mr. Juday appears to demonstrate the basic capacities to understand the nature and object of the proceedings against him. However, he has difficulty discussing and applying these concepts to his case. Mr. Juday has difficulty participating in a rational discussion relating to his legal matters. Overall, Mr. Juday's present mental condition continues to interfere with his inability to discuss his legal charges in a rational manner and ultimately assist with his defense. Mr. Juday would benefit from further restoration treatment within a structured setting to work toward obtaining competency. Mr. Juday, I've talked to you here in the courtroom, on Zoom from the jail in Centerville, and a couple of times from the forensic center. You're always polite, but basically you won't talk to me, and you won't talk to your lawyer. You've been in jail for 455 days or whatever I calculate, 456 days, or at the forensic center. If we could get you to cooperate and open up, this matter could probably be resolved and you could get released. But at this point, we're stuck in this closed loop of you not wishing to talk to anybody or assist in your defense. Are you willing? Is there anything you want to say to me here?
And there ain't nothing to talk about, man. I still plead the fifth.
All right.
All right, man. It shouldn't even
Well,
go this far.
All right. Now, as a rule, well, the Fifth Amendment says that the defendant's statements cannot be used against him if they're taken in an involuntary manner. Your statements to the doctors are exempt from use in any criminal proceeding against you. Your discussions with your lawyer are privileged. Anything you say to your lawyer cannot be used against you. There's an absolute attorney-client privilege that protects that relationship. So at some point, you're going to have to talk to somebody, or we're going to be here for a long time. What the actual allegation was is that you...
What do you want me to do? Just have a conversation with them about whatever?
Well, not even necessarily about...
You want to talk about sports? What?
Yeah, talk about your ability to assist with your trial. Understand the charges against you, be willing to cooperate with your lawyer, be willing to answer her questions. You don't have to tell me a thing, Mr. Juday. You're right. You have a Fifth Amendment right not to testify or disclose anything if you don't wish to. I can't call you to the witness stand and put you under oath and say, tell me what happened.
I've already talked to Rhonda too. I told her what she needs to know. Like I said, what else you want to talk about?
She wants to talk about whether the prosecutors offered a plea agreement, whether you would accept the terms of the plea agreement.
I ain't taking no plea, man.
All right. Or whether we're going to have a jury trial. Right now, the case is still in district court. The charge is a felony. We haven't even gotten past the preliminary examination stage. Now, your brother Mike is here. He's concerned about you, and he's been in contact with the court. They may pursue an involuntary commitment, but at some point, the clock is ticking. I encourage prosecution and defense to take a look at the mental health code, because we can't kick this can down the road forever. I think it's 15 months.
It's a joke, man. It shouldn't even gone on this long.
Yeah, that's regrettable, but it's not like part of it isn't your fault. I'd like to have this case over with a year ago.
Yeah,
so, yes, well, I make a finding that I adopt the opinion of the forensic examiner. I find that the defendant is incompetent at the time, but restorable. He shall remain under the supervision of the Michigan Department of Health and Human Services. He is presently at the Center for Forensic Psychiatry. As a condition, no, you're not released, but James, I think we can get this case resolved either by plea or trial, but we got to get past this hurdle. I believe this is the last time we can do this. Anything further would have to be a petition for involuntary hospitalization. And Mike is aware of that. But we need to, and I've looked at it, you guys need to look at the statute regarding competency and continued commitments. Mr. Juday, my advice is try to cooperate with the people and cooperate with your lawyer, and let's see if we can get past the competency hurdle to either get the matter resolved in district court.
I have been, man.
All right, sir. I wish you luck. I'll be seeing you probably within the next 90 days. All right, Mr. Juday, they're going to hold on to him for a while longer, but at some point, if he's found not to be restorable to competence, there has to be a petition for involuntary hospitalization. We've got people that have never been competent again, and there's one man, he's been at the Forensic Center for 35 years, and once a year they have a competency review. I don't want that for James. It's the kind of case where he probably would get time served if we could ever get the case to the finish line. All right, thank you for being here. Do you have the information on how to contact his lawyer?
Yes, sir.
All right, thank you. You're good to go.
Thank you very much.
We've got another one coming up with the gentleman in Three Rivers that believes he owns a piece of the parking lot. That's on a 90-day misdemeanor. He's been in custody for a year and a half.
It's amazing how patient Judge Middleton is, but the defendant won't listen to reason. The judge explained to him that any conversation he has with the doctors or his lawyer cannot be used against him, and if he had cooperated, he could have been released a year ago. He may be playing a game, but he's so irrational that there has to be serious mental health issues. Anyhow, that's my opinion. What do you think? Let me know in the comments. Be sure to subscribe and give me a thumbs up, and thanks for watching the video.